Judge Hussein,
Yeah.
it's 11 o'clock, but only half of the people is in attendance at now. Would you like to wait
Yeah, let's
another 4 minutes or so?
yeah, Betty, let's give them a few more minutes.
Okay.
Yeah.
Judge Hussein,
Yep.
we can start.
Okay. Right. Good morning, everyone. First of all, I must apologize for the postponement. I had lost my voice completely. It's still a bit croaky, but we can manage. It's the first time ever in 41 years of practicing that I lost my voice. It's the most terrible thing. Except that I can't understand my wife of 41 years. She's never lost her voice. I wonder why. And looking forward to the day when that happens. Um, let's, just before we get going, just a few things. This is about virtual hearings. Now, some of you might question the relevance of it because our courts have gone one way and then back again. We started in this province, particularly in Gauteng, we were doing everything virtually. The SCA everything virtually, the Constitutional Court, the Labor Court. But that cannot be said for the other courts in the country. Now, the trend is going the other way, as I will show you. However, what is clear is that there are two considerations. Let's first stick with court appearances. There is a lot that you can do in trial preparation. In other words, the pre-trial proceedings, things like consultations, case conferences, pre-trial conferences, all of those things can be done virtually. And I'll show you the advantages of that. Again, with court hearings, we also have a situation where you have an in-person trial, but a witness is not available. The witness is, say, living in London. In the past, we took evidence on commission. It was time-wasting, costly exercise. It created postponements and so on. We don't have to do that anymore. What you do is a witness who is not available to come to court for whatever reason, you can hook them up virtually and the person can still be heard. Those of you who follow these hearings around the public protector would have noticed this morning that they had a bit of a hybrid going in court. There were some advocates present in court. There were other advocates addressing the court online. So that's also something that can be done. Then you have the second consideration. Many of the firms will have, those firms that deal with dispute resolution, and I'm assuming all of you attending this will fall into that category. You will be using alternative dispute resolution methods, which means that you will be doing arbitrations, mediations, negotiations. Those things can be done on a virtual platform. And I'll show you that it's become still the preferred method of dealing with arbitrations. AFSA, for example, as well as other institutions that offer arbitration facilities, actually have very good virtual platforms to do arbitrations. Now, the default position during COVID was that we must have virtual hearings. The SCA, for example, if you applied for a date, you got a letter from the registrar which says that the default situation is that it will be a virtual hearing. They did not want in-person hearings. The Constitutional Court did the same thing. I must tell you, in May this year, they reversed the situation completely. So complete about turn. Now they said the default position is in-person hearings. Currently, the SCA does not hold virtual hearings. And this they did after making some very strong obiter about the refusal to attend virtual hearings. There are judgments, there are two judgments, I think I referred to them in your notes, where NAFSA, a judge of appeal, Mohammed Nafsa, he was faced with an application by a litigant who didn't want to have a virtual hearing. Well, Nafsa's view was very simple. He said the process here is that we are hearing it virtually. If you decide you don't want to attend virtually, well, that's your problem. We're going to proceed. So, having made very strong judgments, obiter dicta about virtual hearings, they suddenly made an about turn. I must say, though, speaking for myself, I was in the SCA last week, Thursday, arguing an appeal in the conventional way, 5 judges. I must tell you, it was an absolute pleasure. I also presented argument virtually in the SCA, and it was terrible. You know, you get these 5 faces on the screen. You have to now concentrate on the argument, and you don't know at any given time one of those faces is going to address you and ask you a question. Those of you who watched some of the hearings recently in the Constitutional Court, you've got 9 faces on the screen, and seriously, it looked like 1 or 2 of them had fallen asleep. So, you know, it's very difficult to connect, and I'm going to take you through some technique on how to deal with that. But during the pandemic, the virtual hearings were confined mostly to Gauteng, both our divisions here, the Labor Court, the SCA and Constitutional Court. The other courts in the country didn't have capacity. For instance, many of the high courts, even now as we speak, do not have Wi-Fi, or they do not have stable connectivity. That's a real problem. Now, just to alert you, the Department of Justice is currently embarking on introducing electronic filing throughout the country. We have it here on case lines, and all our papers are filed electronically. It's not without its glitches, as you can imagine, but now they want to roll it out throughout the country. The same software, which is Case Lines, it is well-proven software used in a number of countries around the world. And the Department of Justice decided that they will roll that out themselves. The pilot program in Gauteng was done by Reuters, who owned the software. So an outside service provider was engaged to run the program. Now, it worked very well, but you know, it's our government. So suddenly the whole thing went offline. Why? Because they didn't pay the service provider. So they walked off the job. You know, that sort of thing happens. Now, I'm told that SITA, that's the State Information Information and Technology Agency, is going to be rolling out doing this the rest of the country. Well, that's not good news. Those of you who are familiar with SITA will know that they don't get things right. But the whole program has been set back by, you can guess, corruption. They found that 3 senior staff members in the Chief Justice's office had set themselves up to benefit something like 54 million rands worth from the same rollout of e-filing. So if we don't have virtual hearings in future, or if you take the other divisions, if virtual hearings are not going to happen, one thing will happen is that we will have a paper-free court. That's the whole idea. So when you get to when it comes to filing pleadings, motions, affidavits, reviews, appeals, it will all be done electronically. And that is why I brought in Advocate Doris Goodenough, who has the license for software called Cognotes. It's one product that's available. she will show you how this works. So you'll have electronic filing, but you can also have your own documentation in court electronically, and it makes it a lot easier to navigate rather than have to navigate through bundles of paper. So after June 2021, the courts began to rethink the best way forward because we are no longer facing a pandemic. Now, what I want to do is take you through some of the proposed guidelines that came out of Gauteng. Now, remember, whatever happens in Gauteng is usually followed in the other provinces. Some of these have already become irrelevant, but they are worth looking at as they are likely to come up. Betty,
Judge?
there was a hand up. See what the problem is?
Okay.
So what they've decided is that it is now the prerogative of the presiding judge to determine whether a civil matter is heard in open court or virtually. Now, this applies only to civil cases. As you can imagine, criminal cases, it is not preferred to do them in a virtual court, virtual hearing. And you can imagine the disadvantage that you have in a criminal case where cross-examination of witnesses is absolutely crucial, okay? So the judge may decide it. Now, in matters where evidence is required. Now, remember, virtual hearings are perfectly suited for motion procedures, that's unopposed and opposed, reviews and appeals. That is why the SCA and Constitutional Court very comfortably heard matters virtually. But hearing evidence, that's a whole different matter. The judge retains the discretion to determine whether the matter should be heard in open court. Now, these are the factors the judge is supposed to take into account. The submission of the parties on whether a physical court hearing is preferred, the nature of the evidence, whether the parties have the means to attend court. If a virtual hearing were to be conducted, whether any of the parties would be unable to access electronic means for the period that the matter is to be heard. Now, that's very important in this country where most of the population do not have access to electronic means. They don't have the devices, they cannot afford the data. If a virtual hearing were to be conducted, whether any of the parties were unable to access electronic means, whether justice will be properly served. Now, this is the open joker in the pack, which is there for the benefit of lawyers to make an argument. Where the issue of whether justice will be properly served, the interests of the parties, where the matter to be conducted either in a courtroom or by electronic means. Now, just to go back, can you imagine cross-examining a witness where you, in a virtual hearing, where you're using an interpreter? It is really quite impossible. We've tried it. It can work, but it's time consuming. And as I will show you, the lawyers are at a disadvantage, serious disadvantage, when it comes to things like demeanor, credibility, maintaining a certain pace, where the witness is allowed to evade answers, where the interpreter doesn't understand his role, the interpreter disappears, then appears again. It is just such a mess. The directive also says it is preferred that admissions of legal practitioners be conducted in open court. Now that I think is a no-brainer. I can't think of anyone, any of you, would like to be admitted virtually. Okay, it is the most important step in your career. You want to stand up in court in your robes. You want your family to be in the gallery with their cell phones taking pictures. It's an occasion. So yeah, imagine being deprived of that because you're doing this virtually. I mean, can you imagine you tell your mother that you're being admitted, but we'll do it from the dining room. It just doesn't make sense. Where no evidence is required, for example, in urgent court and in motion proceeding, the discretion remains that the presiding judge will determine the method of hearing. You know, usually we don't hear evidence, oral evidence in urgent court. And we often have after hours urgent hearings. Virtual platforms are perfectly suited for that, especially in the cities like Johannesburg, Durban, even Cape Town, where judges find it unsafe to drive to court at night. I mean, those of you who haven't seen this, go and look at what it looks like outside the Johannesburg High Court in the evening. It will scare you to death. You wouldn't want to be there at night. Usually what we did is that we had urgent applications at the judge's house. That too has its disadvantages, especially where the judge has to hear evidence now in an urgent application. And that's where the problem starts with after hours applications. There's a need very often to hear evidence because there's not enough time to write an affidavit and serve it and file it. So the trick is to speak to the judge and ask the judge if he would like to hear it hear it virtually. Most judges will prefer to have it done virtually. So whether we have a pandemic or not, I think those of you who have a practice where you do urgent applications, you must be geared up for virtual hearings because you will be bringing after hours urgents virtually. Then we have case management meetings with judges. That can be done easily on a virtual platform. It saves you the trouble of driving to court, finding parking, avoiding getting robbed in Pritchard Street, and getting into judges' chambers where you'll have to walk up 8 flights of stairs because the lifts don't work. And eventually you sit down in the judge's chambers. It's a mission. Much easier to do it virtually. I will also show you that when it comes to pre-trial conferences or case conferences with your opponent, you don't need to do it in person. Why should you drive to somebody's chambers or offices for a pre-trial conference when you can achieve the same result virtually? Okay, and I'll say more about that later. As far as appeals in the High Court are concerned, the presiding judges retain the discretion to dispose of the appeal without hearing oral argument or to hear argument, whether in court or virtual platform. Now, with appeals, it is compulsory to file heads of argument. The judges may decide that they can deal with the matter based on the record and heads filed by the parties. They might indicate that there's no need to hear oral argument, whether it's virtual or in person, doesn't matter. One of the advantages of virtual hearings is that it boosts access by making it easier for participants to appear, particularly where parties are unable to come to court due to illness or inconvenience, or they may be out of the country. So what it does is that it avoids the delays of postponements where the matter has to stand down to find a witness. Virtual hearings ensure that the case can still be heard if the individual can appear via video link. We had a decision, there's a judgment, I think it's Judge van Nieuwenhuizen, where they were in a matter and a trial where the witness was in London and couldn't travel because of COVID restrictions. And the parties asked for a postponement. The judge says, no, that's not necessary. We can hear the witness virtually, connect them up on the video screen. And that's how the matter was dealt with. And they avoided costs and delays. Now, what's happened recently is that the members of the profession, and I'm talking to you, what do you prefer doing? Would you rather have virtual hearings, or do you want to be in court? The choice, I must tell you, is a no-brainer. Depending on the nature of the case, if there's oral evidence, if it's important to argue your matter orally, always go for in-person hearing. But where there's no witnesses, it can then conveniently be dealt with virtually. The Pretoria Society of Advocates approached the judge president recently to say that civil trials must be heard in court and not virtually. That's being considered. But about 3 weeks ago, our deputy judge president, Sutherland, actually went and spoke to the members of the bar and to the profession, urging them to return to court. Now you can imagine, Judge Sutherland sits in the Johannesburg court, which is our local division. It is surrounded by filth. It is unsafe. Parking is not good. The whole environment is not conducive to professional people coming there to work every day. So he's come up with some reluctance. There's been pushback from many members of the profession saying that they would prefer to do most of their work, where possible, virtually. Now, that debate is still carrying on. The deputy judge presidents, and I assume he represents the rest of the bench, they prefer the lawyers to come back to court. Now, let's quickly look at what the international trends look like. We had virtual hearings all over the world taking place. There were a number of surveys that were carried out, but the focus groups were held in the UK and the USA. Some interesting things emerged. Remote hearings take 34% longer. This is because of technology issues, lack of preparation. Experience tells us that trials take longer with frequent interruptions and stand downs. Well, that's the risk with virtual hearings. When you have to hear oral evidence, you'll have to get a witness on the camera to testify. I will deal with that in more detail later on how to present a witness. But then, if the witness is not in your own office, then you cannot control what happens to the technology. If somebody is at another location trying to hook up on their laptop, you can just imagine in this country where power is uncertain at best, it means that you may not be able to log on. There may be instability on the net and so on. So that adds to the time. So whatever gains you made in not traveling and so on, completely lost because of the time you lose in the actual hearing. And stand downs and postponements happen all the time. The advantage is that participation increases. Participants can connect from anywhere. Court attendance rises, but we are restricted in this country by poor access to the internet for most of the population. That's here. There's no access to the tools, and the data is too expensive for most people. Now, the type of hearing they found was more important than the type of case. Remote technology works best for hearings that are short, limited in scope, or affect people's ability to get on with their lives. Now, I told you one of the things about virtual hearings is that it works brilliantly where there's no need for oral evidence. You don't have to lead a witness. There's no cross-examination. So they are perfectly suited for motion proceedings, appeals, and reviews. Trials can be a problem, especially where there's a multiplicity of parties. You know, there may be 2 plaintiffs and 5 defendants. The issues may be complex. There may be several causes of action. There may be defenses raised by 5 different defendants. There'll be many witnesses. And once you need the interpreters, it really becomes a problem. So if it is a complex matter, don't go for virtual hearings. What you should do is hold a case conference with the judge and say to the judge that you want it in person, but there are certain witnesses who are a problem. You will request that those witnesses only be heard on a virtual platform. So the problems still remain. Despite the advances in technology, in this country, there is still a problem with access to technology and access to electricity, power. Now, although courts are moving back to in-person hearings, the survey, and this is very interesting, in the United States and in the UK, they found that private dispute resolution in the form of ADR is still finding virtual hearings to be useful and convenient. So, and the weird thing is, people said that if they are formally litigating in court, they prefer an in-person hearing. But if it's a private dispute resolution, they would choose the convenience of a virtual hearing. Now, I think one of the reasons why in those countries they prefer hearing matters in court is because of the use of juries. Can you imagine? There are 12 people sitting there as members of the jury. There's a judge. There are all the lawyers. There's witnesses. How on earth you cope with that on a virtual platform, I don't know. I mean, it's hard enough when you have 9 judges in the Constitutional Court. Now, these are the benefits of virtual hearings. And this is why virtual hearings are preferred when it comes to private dispute resolution. Now, that is still the trend in this country. People are still happy to do virtual hearings with arbitrations. So, for instance, I'm involved in a number of arbitrations where the matter is being dealt with virtually. So, accessibility is important. Remote courts are boosting access to justice where parties are unable to attend court for various reasons, including illness. Virtual hearings ensure the case can still be heard via video link. Now, virtual hearings also improve public access, but that's not entirely true for South Africa. Most of our population do not have access to this. Now, remote courts are logistically efficient. Now, the judicial system already had backlogs pre-pandemic. The additional downtime has added to the buildup. Those of you who practice here in Gauteng, if you applied for a trial date in Pretoria, you'll get a shock. They'll give you a date in 2025. Okay? It's as ridiculous as that because they've just built up this massive backlog. So virtual hearings can provide more flexibility and reduce delays. Important discussions which previously may have taken minimal time can be resolved quicker than a gathering in a physical court. Now, what that means, and I suggest you use virtual platforms for this. Case management with the judge, do it virtually. No need to drive to court. Judges prefer doing those things virtually. Interlocutory disputes, those can easily be dealt with virtually. It's quicker, it's cheaper. And of course, travel. We all cover enormous amounts of mileage traveling to court, traveling to consultations, and so on. Apart from the cost of travel, time spent driving, flying. So this can be reduced. And this, of course, gives rise to reduced carbon footprint. This is a serious matter. We should all be taking it seriously. I can tell you from my own experience, since the pandemic, since 2020, I've covered 3,000 kilometers a year in my car, just 3,000. I've hardly had to travel anywhere. Everything was done from where I'm sitting right now. So virtual hearings obviously contribute towards reducing carbon footprint. I mean, we all can see throughout the world what climate change is doing. So ADR will continue to be used in virtual hearings. There's always the possibility that circumstances will drive our courts back to virtual hearings. I mean, you can imagine if there's another breakout of, say, monkeypox or something, we're going to be all back to virtual hearings. I told you electronic filing is being rolled out countrywide. There will be no rational reason why courts have to hold unopposed motions in person. Now, there's no reason for that. And really, as a profession, we should be lobbying the judge's president and the chief justice to introduce virtual hearings for all the unopposed motion courts. There's no with e-filing, there's no reason why we have to go to court travel there, find parking, risk getting stabbed, uh, find your way into the courtroom, mention one unopposed matter, and then go back. Now, there's a huge advantage for attorneys, particularly if unopposed motions are done virtually. That is, the reason attorneys brief counsel to do unopposed motion work is not because they can't do it. It's because it doesn't pay them to do it. For an attorney to take virtually all day getting to a motion court to move one matter and come back just doesn't pay financially. It doesn't make sense. It makes more sense to brief somebody else to go and move the application. So attorneys will brief another attorney to go to motion court, or they'll brief a junior counsel to go to motion court. So it's more cost efficient for an attorney to have virtual hearings of all the unopposed motions. I mean, it'll be such an advantage. Even opposed hearings can be done virtually. The only difficulty I had with it is the delays that happen through connectivity problems. The Durban High Court, for example, they never have Wi-Fi. The judges there, I had to argue a summary judgment virtually. I was here in Johannesburg. My opponent was in Durban. But what happened is that there was no Wi-Fi in the court building. So we had to wait for the judge to drive home so the judge can use the Wi-Fi at home to connect up. So we lost 2 hours. So it doesn't work if the court doesn't have all the infrastructure to accommodate virtual hearings. Now, again, as a profession, we should be proactive. Lobby the Chief Justice's office, the judge's president, and see to it that our courts are well provisioned. You know, some years ago, we wanted to switch to electronic filing and so on in the Johannesburg High Court. The profession, the Law Society, actually went and installed a local area network inside the court. If you walk around the Joburg High Court, you'll still see the cables and so on there. It never worked because the Department of Justice just didn't want to cooperate. So that's always a setback, but we should not take that lying down. Now let's talk about your practice. I say, if you're involved in dispute resolution, be it magistrates court and high court litigation, be it ADR, you must be prepared to hold virtual hearings. Even consultations with clients are being done on the internet. Now, those of you who do commercial work, commercial litigation, you will know that busy executives, directors, managers, they would prefer holding a consultation from their own boardroom. And I can assure you, the corporates are perfectly geared up for virtual hearings and virtual consultations. I do work for financial services providers. I go and sit in a boardroom here in Johannesburg, and we can consult with people all at once from London, Brussels, and New York. No need to travel and fly to those destinations. Now, what do you need as a practice? You must establish the necessary infrastructure. You know, it's a fact that lawyers are extremely conservative and they don't take to new technology very seamlessly or easily. You know, going back to when I was a junior advocate, we used to use a typewriter to produce documents, pleadings and affidavits and so on. And we employed typists. Then the personal computer was invented and typewriters became obsolete. Do you know how long it took the older advocates to decide that, to persuade them that they should get the computer? In my group, all the typists decided they're going on strike if they don't get a computer. That's when we got it. Okay. So my own experience, especially with the small to medium-sized firms, they tend to lag behind with technology. But I must warn you, it is a policy of the Legal Practice Council, as well as the various bar councils, that practitioners must have the infrastructure to practice as independent professionals. There's no excuse. You can't say, oh, well, I don't have the internet. That's not going to be tolerated. And besides, I don't think you'll survive. So go through this very quickly. You must have access to decent computers. Now, the good news there is that computers have got cheaper, they've got more powerful, they've got faster and lighter. No excuse. You must have access to internet. And now, for God's sake, get the fastest internet you can afford, because it makes commercial sense that you don't waste time when you work on a matter on the internet and you're waiting for the damn thing to buffer. Your research as lawyers, you will no longer be using the kind of library you see behind me. It's all done on the internet. I can find case law in a matter of minutes electronically, whereas if I use that library behind me, it could take hours to go from the nota up and follow the trail through to the latest case. That is an enormous advantage, especially to attorneys and advocates, that the less time you spend on research, the better, because you cannot bill clients for all the time you spend on research. So you get, if fiber optic cables are accessible, and that's the case in most business areas, including most suburbs in our bigger cities, you have to get it. You cannot have virtual hearings, whether it's consultations or actual hearings. You can't do that where the internet is slow or prone to technical faults. Now, this is the bane of our lives. You need alternate sources of electricity. A good quality inverter works well. A generator, if you're a bigger firm, you need to get a generator, but remember, they are noisy and very expensive to run. They absolutely drink petrol and diesel. But you know, if you don't have alternatives, then you need to keep the Eskom app on your phone so you can check the schedules. Now, I always advise lawyers, seeing as we're becoming so reliant on the internet, you must have a twin screen system. Dual monitors as a minimum. A number of attorneys use more than 2 monitors. They use up to 4 monitors on their desks. Dual monitors work brilliantly, especially in a virtual hearing, because you can have the judge on one screen and you can have your pleadings on another. Advocate Goodenough will show you a system where you can have all your pleadings electronically and you can be talking to the judge on the other. Your computer must be in front of a blank wall, far from distractions. Having a set of books like you have here behind me is not a problem. You're not supposed to park yourself in front of a very prominent logo of your firm or your name. So you can't do some ambush advertising that's frowned upon. The other problem is, and I had to deal with an urgent application in Pretoria. The judge was hearing it from her house. She didn't realize that she had sat down in front of her husband's bar. Okay. So we were talking to her, but we could see all the bottles of booze right behind her. It was quite hilarious. She didn't realize what was happening until we were about an hour into the application, that she quickly apologized and shifted to another location. So you can avoid these things. Now you must have a separate witness room where the witness can testify away from anyone who could possibly influence the witness. Now, in a virtual hearing in court, a judge will require reassurance from you, the practitioner. If you use arbitration facilities, most arbitration facilities do have witness rooms with the cameras and all the other technical requirements. The twin screen is also something that's very important if you are going to consult a lot virtually. Because in a commercial practice, for example, where you're drafting documents, contracts, and so on, what you will require is to put the document, the draft, up on one screen to be your client will be looking at the contract, and you can talk to them on another screen. Sharing the screen works, as many of we are doing right now, but I'm talking to you with twin screens. I've got the PowerPoint on my left, and I'm talking to you on the right. Works very nicely. You must get the best audio visual system you can afford. Okay. There are those colleagues who are absolute gadget geeks. They've got every gadget under the sun. I mean, they walk around with a bag full of gadgets, and they've got the state of the art of everything. Now, that's an expensive exercise. You don't have to do that, but go and test the equipment and find the best you can afford. You can't, I can't be talking to you now if I had to use a headphone and a microphone and so on. I've got a device on my desk and I can talk to you from anywhere in my chambers. So it works very well to have a good system. I told you that the technology is necessary for pre-trial conferences, case conferences, and witness conferences. You don't have to drive to your opponent. Now, when it comes to virtual hearings, I want to give you a piece of advice. Please take this seriously. If there's one thing you're going to take away from this webinar, is this. When you present a case, be it an opposed motion, unopposed motion, an appeal, a trial, you must prepare first-class papers. No sloppy drafting. You will prepare 3 sets of affidavits. You must draft brilliantly. I'll tell you why. There are 2 things. Firstly, judges know this is going to be a virtual hearing. They will anticipate that there will be glitches, technical glitches and delays. They will want the actual virtual hearing to be as short and efficient as possible. They are not going to listen to long-winded argument. They are not going to listen to lengthy addressing by practitioners. They will want to get to the point very quickly. The question of relevance is most important. They will confine you to a relevant point only. You are not going to be allowed the luxury of expansive argument. What judges do is they rely heavily on the papers. Before they go into a virtual hearing, a judge will read the papers. Now, if you drafted a bad founding affidavit, it's not very good. The judge doesn't find it particularly persuasive. Before the matter is even heard, the judge is against you. You've picked up a problem already. If you drafted an answering affidavit, which just has bare denials, the judge is not convinced that you've got a defense. You are going to lose even before you address the judge. The persuasion in a virtual hearing really happens before you start. Now remember, I will show you that the art of persuasion is somewhat lost in a virtual hearing. The eloquence of a lawyer standing on his or her feet in court, making eye contact with the judge, is lost. Okay? You need to adapt. I'll show you how to adapt. But the persuasion starts with the drafting. I always tell practitioners in a virtual hearing, always draft not good heads of argument, but excellent heads of argument. The judge will read your heads, and that's where you're going to win the case, because your eloquence is not going to matter anymore. The judge would have, they make up their minds. The judges come to the hearing with a prima facie view based on the papers you filed. So if you filed rubbish heads of argument, the prima facie view in the judge's head is that you don't have a case. So look, as a rule, you're supposed to draft well and draft excellent papers as a rule for any hearing. But when it comes to virtual hearings, it really matters. You are not going to have the advantage of swaying the judge on your feet in court, okay? You know, when you file decent heads, good heads, the judge reads it, sees the point, likes the point. In a virtual hearing, I've seen judges say to counsel, Mr. Smith, there's no need to hear you. I'd like to hear your opponent on a certain issue. Smith's won the matter, I can tell you. It's brilliant when the judge says, no need to hear you. Let me hear your opponent. If you want to succeed in virtual hearings, you must prepare first-class drafting. Your drafting has got to be excellent, okay? That's the secret. Even in a virtual pre-trial conference, the way you draft the agenda, the way you request admissions will be a game changer, okay? You're not sitting around a table. You'll be referring to documentation. That is why, even there, at that level, you have to draft well. Now, the thing about virtual hearings is that it is nothing more than an adaptation or adjustment of a conventional hearing. So whatever you did in a conventional hearing still applies to virtual hearing, but now you're going to adapt. And that's what I'm going to talk to you about. Where are the problems? What are the challenges facing you? Now, the biggest problem is that trial technique or trial advocacy is a performance skill. When I speak about the eloquence, when I speak about the persuasion, being able to turn the judge around in court, that is a performance skill. It is a skill which lawyers perform on our feet. I can assure you, ask any trial lawyer, you are at your best when you are on your feet in court. But now you are not on your feet, you are in your seat. You're sitting there in front of your computer, trying to come up with the same eloquence that you do in court. Now you know why cross-examination doesn't work well virtually. There is a distinct disadvantage. Now, these are things that you have to consider. Betty, I've seen the time, but I want to deal with this first. These are the things that you're going to have to change. Performing while sitting down. That's the main one. The question of demeanor. You can't see the witness. You're seeing a face on the screen, shoulder upwards, like you're seeing me now. Leading a witness of whom only a face appears on a screen, and it's a small screen. Cross-examining a face on the screen. Presenting argument to a screen. Trial lawyers are at their best on their feet. The first area of adaptation is the ability to address a judge or an arbitrator while sitting down in front of a screen. Now, the preparation is the same as for a conventional hearing, but you have to do some things differently. Firstly, and here comes my advice again, your papers, be they pleadings or affidavits, statements of claims, statements of defense, must be well drafted and a model of clarity. Now, one of the problems that we see with drafting is that practitioners are still, even now in the 21st century, are stuck to precedents which were developed in the 18th century. I mean, that sounds like a joke, but that's exactly what we see. Yesterday, I was training markers, people who are marking the bar exams. In the legal writing paper, we gave them particulars of claim to draft. We warned the pupils, do not write out of precedence. You will fail. And we instructed the markers, if it appears that the pupil used a precedent, and you can see it because the pleadings don't bear much resemblance to the facts of the case. Now, the worst thing you can do in a virtual hearing is to prepare bad papers where you do not set out the material and peculiar facts of your case. You used a precedent. It's like that stupid averment you see in motor car accident cases. He failed to keep a proper lookout. What on earth does that mean? I mean, I ask you, nobody can explain what that means. Okay, but the facts are that the defendant drove through a red robot. Why on earth can't you say that? No, you'll plead he failed to keep a proper lookout. Don't do that. Failure to communicate. What on earth that means, I don't know. Okay, no love and affection. I mean, she beats him up, for God's sake. That's the problem. Why can't you plead that? That's the first problem. Get the pleadings right. Get your affidavits right. Your heads of argument must be logical, easy to understand. The judge sees the point. And most importantly, please take this as gospel. When you're dealing with virtual hearings, do not file voluminous papers. Do not file founding affidavits that's that thick. You are going to pay a price for that. I know the judge may have it electronically, but it's still a mission. They still have to read it. They are not, judges don't like reading thick files. They're human beings. All of us hate thick files. You know that heads of argument, we've imposed page restrictions in the SCA, in the Constitutional Court, here in Gauteng. Why? Because lawyers were filing hundreds of pages of heads. Doesn't work. With virtual hearings, keep it short. Your heads must be short. 40 pages is maximum. Try and do it in 20 if you can. Okay. Minutes of pre-trial or case conferences must set out what the parties agree to be the issues for trial. Now, you can have a case conference in an opposed motion. Why can't you meet virtually with your opponent and say, let's agree on what the issue is here so that we confine the hearing? If it's a virtual hearing, you want it to be as short and as efficient as possible. Thirdly, I've dealt with this. Heads of argument, they have to be excellent and they must be short. Just remember, long heads don't work. And by the way, sorry, by the way, what causes a problem? What makes papers voluminous is this habit that attorneys have of annexing everything to their papers. So there's a 200-page service level agreement. The attorney will say in the affidavit, and a copy of the agreement is annex marked A, 200 pages. But it's only one page, only page 8 is relevant. For God's sake, don't do that. The judges will hate it. What you want to do is say the relevant page is annexed here to, marked A1 to A2. A copy of the contract will be made available at the hearing. Keep it short, okay? When you file heads of argument, you want them to persuade the judge before the judge comes into court. Now you've got a great start. You want the judge on your side before you appear on that little screen. The secret lies in preparing even better but shorter heads of argument. Take my advice, you will not go wrong. Excellent drafting always matters. The judge must be impressed as soon as they read the papers. What judges want to do? They want to see what happened between the parties. What are the material facts? They don't want to read papers that came out of a precedent. That doesn't help the judge. Then the judge wants to see what are the issues between the parties. Now, if it is a trial, you are supposed to, in terms of the directives, agree with your opponent what the tribal issue is. The judge doesn't want to read the pleadings because judges know pleadings are not particularly helpful. So they'll say to the parties, you tell me what's the issue, forget the pleadings. That is usually recorded in a pretrial conference. So take the pretrial conference very seriously. Now, argument is never expected to last long. Where you're dealing with an opposed motion, appeals, your argument has to be brief. Now, those of you who followed some of these applications in court around the public protector and Jacob Zuma and so on, you'll see that on many occasions, the judges have to remind counsel that, listen, you've dealt with that point. Can we move on, please? That is going to happen all the time because the judges expect you to stick, to be relevant, not repetitive, short, sharp, sit down. That's what they want. You must never sound boring. Okay. Now, I told you it's difficult when you're in front of a screen, but you can adapt. You can be equally eloquent, equally persuasive in a virtual hearing. Okay. The judge will see you in a small screen, but that doesn't mean you must talk to the judge in a sleep-inducing monotone. Just stop that. One of the things that requires adaptation between the parties is excellent cooperation between the litigating parties. Now, here, I want to diverge just a little with commercial litigation. Now, I can tell you, you are not likely to do commercial litigation in the High Court. Nobody does that. It goes to arbitration. But whether it's at arbitration or in court, doesn't matter because the rules of discovery are the same. One of the great advantages of virtual platforms is how you can deal with electronic documentation, especially in cases where the parties have accumulated thousands, sometimes millions of electronic documents. This includes access to hard drives, access to metadata. You don't need to go to somebody's office to carry out an inspection. These documents are handled electronically. They are sent to you in a file. You then have to analyze and come to an agreement. The point I'm making is that you will meet virtually with your opponents, first with your client, then with your opponents, and come to an agreement as to what documents are relevant. Just get one thing straight. If you go to a judge with discovery that runs into thousands of pages, the judge is going to throw you out and make you pay the costs. The judge will ask you a simple question. You've got a 3,000-page bundle A. Tell me, are 3,000 pages relevant to the issue before me? The answer is never going to be yes. So you'll have to create electronic bundles that are short, strictly relevant to the single issue before the judge. Everything else is cast away. The trick is not to get involved in interlocutory disputes with your opponent. And this can be achieved in a virtual hearing. Now, if there's a dispute over whether or not a certain metadata needs to be made available, you can't agree. Simple. Don't go and bring an application in the opposed motion court. It takes too long, too costly. Call for a virtual case management meeting with the judge. Tell the judge there's an interlocutory dispute. We want a ruling. Done. So let's look at some of the changes. Documents are managed differently. You cannot have lever arch files indexed and paginated. We don't do that anymore. As you will see, Advocate Goodenough will show you how the technology is used. You are expected to agree on e-bundles, electronic bundles, and I told you contains only those documents that must be, that are relevant. Those of you who have followed the Please Call Me case, Vodacom, McCarthy versus Vodacom. This matter went through 2 or 3 opposed applications involving access to documents. The data involved in this case runs into millions and millions of documents. You actually need a search engine on a file so that you can extract the documents you need. It is that big. The judges dealt with it on the basis that go and find only relevant documents, and we want the parties to agree. We want to see no disputes over proof of those documents. So there are document management solutions. You'll see one being demonstrated here later. In complex cases, you want to do that. You can also, in a complex, big budget case, bring in an outside consultant to manage the electronic documents. There are service providers. They're not so common in this country, but if you're in the UK or the European Union or Canada, there are many service providers who will come in and they'll manage all the electronic documents for you. Now, here's the big problem. Witnesses. You have to manage them differently. Again, it depends on cooperation with your opponent. What you do now is discuss with your opponent in a pre-trial conference which witnesses will be presented to give oral evidence. The idea is for you to reach agreement by making admissions of fact to reduce the number of witnesses you will call. There's a case currently on the go which has been getting a lot of media treatment. It's a case of Daniels versus the deputy president and other government departments. It's a dispute over land and it involves many billions of rands. And the judge described the conduct of the lawyers as, I quote, nothing short of disgusting. That's what he called them. And he said so in court. Well, this was in a virtual hearing. The reason being is that the government lawyers were obviously busy with Stalingrad type defenses. The plaintiff's lawyers wanted to get on with the matter. The judge asked them to agree and confine the issues. They never did that. The matter has been running for months, weeks rather. So with witnesses, cooperate. Now, when it comes to arbitration, usually the parties agree to swap witness statements. There's no rule in the High Court where the parties are obliged to swap witness statements. That only happens where a matter starts off in the motion court and then is referred to evidence. There, if a witness is called who has not testified to deposed to an affidavit, then a statement is provided. Swapping witness statements is absolutely brilliant. It works really well. Those of you who get involved in cases where you know that your opponent is just messing around, insist that the parties swap witness statements. You will be amazed at how quickly the matter gets settled. Now, always agree or confine witnesses to evidence that is relevant to the agreed issue. For virtual hearings, having a witness in the box for hours on end does not work. The evidence in chief must be short, sharp, relevant to the issues, stop. Cross-examination, short, sharp, sit down. That's what you want in a virtual hearing. As I've told you, always try and agree on witness statements. But you know, if you're there to practice some Stalingrad type defenses, you will find it very difficult to agree to providing witness statements. Your opponent will see through it, and you will eventually get into trouble. Once you confine your witness to a particular issue and a set of facts, it is easier to lead in chief. The judges will appreciate that the evidence in chief was short and to the point. This can only be done cooperation with your opponent. Now, if your opponent does not cooperate, you will minute that in your pre-trial conference and you'll draw the judge's attention to it. And now comes the most difficult thing about virtual hearings. They are here to stay. Never mind our courts want to go back. We are still going to use them in ADR and in our courts. Now, judges know that lie detecting from observing a person in the witness box is entirely unreliable. What is demeanor? Demeanor is the judge's evaluation of what the judge sees in the witness box. So the judge is looking at the witness, observing how they testify, observing them under cross-examination, and gets an impression that this witness is credible or this witness is clearly lying. The trouble with demeanor is that it is not reliable at all. The traditional legal perspective of evaluation of demeanor has constantly come under attack by judges. This is because, you know, some witnesses are good because they're confident people, but they're bloody liars, but their demeanor is excellent. So that the danger is that they persuade a judge to believe them. Judges are aware of this. Then you have the other end of the scale where the witness makes a terrible impression, but they spoke the truth. They made a poor impression because they were bloody nervous in the witness box. Now, the one good thing about virtual hearings is the nervousness. The witness is not appearing in a public space where there's an audience, there's a judge staring at him, there's a cross-examination happening. The witness is sitting alone in a room, looking at a camera, getting asked questions over a sound system and responding to it. So that's the one advantage of a virtual hearing, is that they are less nervous, and the so-called signals and signs and symptoms of a lying witness or an unreliable witness is all gone. So if you've got a witness who's nervous as hell and you think they're going to drop you, make sure that they're in another town and connect them up on the internet. It's a big advantage. Just don't say I told you so, because I'll deny it. With virtual hearings, judges will have to place less or no reliance on demeanor. They can't consider demeanor a reliable tool just from looking at facial expression and vocal expression. Look, sometimes it's very clear that this witness is not telling the truth. But with virtual hearings, how do the judges deal with it? It's simple. They will look and rely on the content of the testimony, just as they've done for centuries. So they will look at things like probabilities. Is this version likely to have happened? If aversion is improbable, well, they're not going to worry about demeanor and so on. They're going to reject the version. That's the way judges have done it for decades. They look at things like contradictions, bias, motive, poor recall, lack of detail, no corroboration. These are all the tests judges traditionally used for assessing the credibility of witnesses. Now, as a good lawyer, you will know that this is how judges are making the assessment. What do? You prepare your witness accordingly. You make sure that they have a version to start with, must be relevant, must be admissible, and must be probable. If your witness has a version that is not likely to be believed because you don't believe it, for God's sake, don't call that witness. You're going to lose the case, okay? As the trial lawyer, stick to the proven techniques. Lead evidence in chief and cross-examination respectively. Look at the decision in Standard Bank versus Sibanda, okay? In virtual hearings, demeanor is not entirely lost. All I'm saying is the judges know that it is now even more unreliable than in a in-person hearing. Now, what do you do when you have to call a witness in a virtual platform, on a virtual platform? And you will do this in arbitrations, because that's going to remain with us. That's the future. The first thing, those of you who attended the other courses in the series would have heard me talk about witness briefing. That is where you explain to the witness the whole procedure. You do the same here. Explain how it works, who are the role players who will interact with the witness, and what to do when the judge asks a question, and how to deal with cross-examination. But very importantly, take the witness through technology and explain how it works. Show the witness how to use the technology by simulating a hearing. That is very important. You know, most of you watch television, sports like cricket or rugby or soccer. Did you see how people perform when they know the camera is being pointed at them? I mean, these are sane, normal people. They turn into morons the minute you point a camera at them. Well, cameras have an effect on people. You've got a witness sitting in a room on their own. A camera is pointing at them. They may not act normally. You have to tell them how it works. Do an assessment of the witness's voice. See how it comes across on a speaker, on the system. The judge does not see or hear the witness in person. The judge is relying on a voice that is electronically delivered to the judge. So the judge does not require the witness to mumble, have voice fade. That is a distraction. And the problem with virtual hearings is that it is even easier for the judge to lose interest in the witness than it is on an in-person hearing. You've seen it in court. The witness is testifying, and the judge has put his pen down and is looking around, ignoring the witness. The judge stopped listening. Why? Because the judge lost interest in the witness. Now, can you imagine how much worse this is on a virtual platform? This person is testifying on a screen. What does the judge do? Turns off his camera and mic and goes and have a cup of tea. You don't know. So the judge then comes back and says to counsel, when do you think you'll be finished? The witness was useless to your case. Now that can happen in a virtual hearing. So what the judge will see is the witness's face and hear the voice. It's not enough to measure demeanor, but it can still make an impression on the judge. The minute the judge struggles to hear the witness or understand the witness, there may be problems with accent, which is common in this country, the way speech is delivered. You need to test it. Test it in your office. Put this person in another office on the internet, hear what they sound like, and then make adjustments. Absolutely important. Now, the witness's facial expressions will be there. How the witness delivers the version, you have to show the witness how to talk without causing any distractions. The biggest difficulty you'll have is to get the witness to talk naturally while being in front of a camera. That's the point I was trying to make. People react in a weird way when you point a camera at them. And that can happen in virtual hearings. I've seen that happen. Briefing a witness while they're seated in front of a camera, testing it, showing them the technology is very important. Things like someone's hand goes up. What does that mean? Your opponent may object to something. The hand goes up. The witness has to stop talking. Then the judge starts talking. Then your opponent starts making objections. It's not easy to handle, okay? So you do the briefing in front of a camera. Make a recording. Put it on a monitor. See what it looks like. Okay. Now, the usual rules and techniques regarding in chief apply. But there are two situations. Firstly, your witness is in the same room as you. And secondly, the witness is connected from a different room or a different location altogether. What this means is that you got no control over the witness. Now you know why the witness briefing is so vital. Your witness may be testifying from London, or worse, from Polokwane. Well, if it's Polokwane, then the internet will crash. So it's a nightmare. You have to do the witness briefing. To the judge, it doesn't matter whether the witness is in his presence or on the screen. Especially a judge who thinks demeanor is a lot of nonsense. He's not going to pay any attention to it. The judge will just want to listen to the version. When the witness is with you, it is easier to manage the witness. You can deal with technical glitches, for example. You are able to deal with any problems raised by the judge. You'll be able to deal with when your opponent puts up a hand. You were able to make an assessment of the audio-visual quality. All of those things you can control. Now, the secret is, if you are going to call witnesses virtually, your witness, it is better to have that witness in your location, in your office, where you can assist that witness when it becomes necessary. It's better than to have the witness in another town or across town in the same city, okay? The risks are so much greater if your witness is away, not in your presence. With virtual hearings, you are not in the presence of the witness, and the judge sees a face on a small screen. Eye contact is very important, but it's impossible on a virtual screen, okay? Now here's some suggestions. Planning the evidence in chief now takes on a greater significance. At the outset, you must be aware of the fact that your time is limited. You have to be short. Keep the evidence relevant to an agreed issue. You must have a logical structure. Those of you who attended my previous course will know that with witnesses, you are supposed to have a chronology document in front of you. The witness must be aware of that chronology document. Just deal with what's deal with that version in a sequence and keep it short. The method of headlining and looping works brilliantly again. You must avoid leading questions. When you're dealing with disputed facts, avoid the leading questions. And you'll also avoid confusion. In virtual hearings, it's really doesn't work very well when your opponent wants to say objection leading question. Your opponent has to put the hand up, then the judge will say, yes, Mr. Jones, and Mr. Jones will say, leading question, my lord, I object. The judge then makes a ruling. The witness is now confused. It doesn't work, okay? So stick to the technique that is tried and tested. To avoid leading questions, use the headlining technique and the looping method, or the piggybacking method, as we call it. Also, what avoids confusion is to maintain a chronological sequence. Use a chronology document. There has to be clarity, as you cannot ask the witness to keep repeating the evidence. That's another problem with virtual hearings, is that the witness is not with you. So you'll say to the witness, the judge doesn't hear it, or the judge doesn't understand it, or the witness doesn't understand your question. Now you have to repeat it. It doesn't work. Your questions must be clear, understood the first time, and an answer must come from your witness. Then there's the obvious warning. Do not lead any witness whose version is improbable. I mean, just don't do it, okay? If you've got a witness who's another Oscar Pistorius, well, tell that witness to bugger off. You're not going to call them. Never, in a virtual hearing especially, where you are confined to a short, sharp version, don't come up with a short, sharp version that is improbable. It's really an abuse of process. To manage audio, then there's the question of audiovisual and documentary evidence. This is a big problem with witnesses. Remember, they will be relying on you to show them the correct document on the screen. So you'll be sharing your screen with the judge and with the witness, where you will have your electronic bundle with you. The problem comes with exhibits. You'll have to hold this up to the camera. They must see it. Do you recognize this firearm? It's really a mission. How do you solve that problem? Deal with it in your briefing. Prepare the witness. Show them how it's done. Demonstrate it. What you don't do in a virtual hearing is surprise your own witness. What you want to do is be able to refer to the visual evidence, including documentation, by using the technology. Again, if you have good cooperation with your opponent and there's no disputes over proof of documents, you will not have to lead evidence. It works much better. Finally, I say when you have the facts in your evidence in chief, just sit down. Okay? Just stop. You don't have to carry on. But the most frustrating part for you will be cross-examination. It is frustrating to cross-examine in a virtual hearing. And you know where the problem lies? In-person cross-examination, you can use the method of short, sharp, leading questions. Put the answer in the witness's mouth, move on to the next question. At the same time, you are maintaining eye contact with the witness and eye contact with the judge. Now, here's the problem. What you're seeing is a small face of your witness. You're seeing the face of the judge. The judge doesn't know you're making eye contact with him or the witness. The judge doesn't see all that. The whole effect is lost. You have to work a lot harder. I mean, the witness gives an evasive answer during cross-examination. You know, this idea of giving the judge a knowing look, it's lost. It's absolutely lost. Now, here are some helpful suggestions. Firstly, if it is not necessary to cross-examine, don't. That's the first rule. It applies in in-person hearings as well. You must have a structure. You must know what you want from your opponent's witness to prove your case. Remember the purposes of cross-examination. You must know which of those purposes you want to achieve. Only ask questions to achieve that purpose and then stop. And always stick to the technique. If you don't know the answer to a question, don't ask. Okay? Keep your questions strictly relevant. This gets 10 times more difficult when you're using an interpreter. Because remember, very often you don't see the interpreter. You're seeing the witness and you're seeing the judge. You've got your opponent on the screen as well. You may not have the interpreter on the screen, but you will hear the interpreter interpreting your question, hearing the answer, interpreting the answer. It is not easy to manage. Now you know why the Pretoria Bar want trials to be back in court. And as much as demeanor is not important in these virtual hearings, facial expressions still count. When the witness is responding to a sensitive question, the judge will look at the facial expression. When you see a significant change in facial expression, you know, there are some people who don't know how to maintain a poker face. You can read their faces. They express themselves on their faces. Make a note for purposes of argument. But there's little advantage to be had in a virtual hearing with demeanor. Even worth looking at the judge's expression. I think it's important if you're cross-examining a witness. When a judge is looking disinterested, the judge is not writing notes. The judge is looking distracted. It means that you went wrong somewhere, or the judge stopped listening. Don't prolong the agony. Stop. The way you will hold the judge's attention is to use the short, sharp, leading question method, get the answers you want, and then stop. Lengthy cross-examination does not work. It is not easy for a witness to cover up an evasive response. Oh, by the way, you know that one of the advantages of the virtual hearing is that it's recorded and can be played back. So you can see the witness testifying and not just merely reading a transcript. When a witness becomes evasive under cross-examination, do not dwell on the question. You know, the trick with cross-examination, and this is something practitioners find very difficult to do. The witness gives an evasive answer. Now that's good for you. So you got the evasive answer. You've got your basis for your final argument. Move on. Don't try and rub it in. I've seen practitioners say, well, Mr. Jones, that's an evasive answer. Well, why do you do that? It isn't. Just get the answer. Never try and comment during cross-examination, especially in a virtual hearing. Reserve your comment for your heads. In your heads, you will say, Mr. Jones was an evasive witness. Look at his answer to this question. Okay. So you can review the witness's performance from a recording for purposes of your heads. That's an advantage. Now, Betty, I'm not sure when I'm supposed to give the break.
Judge is saying you can do it now.
The break.
The normal break, yeah.
I just want to check where I am with my. I'm just trying to see. Yeah, okay, we'll take the break now. Doris, shortly after the break, you are going to present your cog notes, okay?
Yes,
So
thanks.
shall we do 10 minutes, Betty?
10 minutes is fine, Judge.
10 minutes, please. What's the time now? Okay, we'll come back at 12:57. 1 o'clock. Let's come back at 1 o'clock. Okay. Let's come back at 1. Okay, take a break. Can I start, Betty?
Yes, please, sir.
Okay. Doris, I'll be another 10 minutes and then over to you, okay? All right. This, what I want to talk to you now is very important. It's presenting argument on a screen. Remember, argument in a courtroom is happening between you and the judge. It's one-on-one. On a virtual platform, it gets a bit tighter. You can see the judge, just his face on the screen, but the judge also sees you as a face on a small screen. Now, the secret to success is not merely an eloquent presentation. It is the drafting of excellent heads of argument. Take it from me. In any matter that you argue, be it a motion matter, opposed or unopposed, obviously in an appeal you would have filed heads, a trial, you are not compelled to file heads in a trial. But take my advice. If you do a trial on a virtual platform, whether in court or arbitration, always prepare heads of argument. Tell the arbitrator or the judge that you would require time to prepare heads. They will appreciate it. You will always get time. A good lawyer, you would have had draft heads already before you started, because it's those heads which actually informed you on how to run the hearing. That's the proper way to deal with it. So if you did that, all you have to do is amend those heads. It shouldn't take you more than a couple of hours, and you can present it to the judge. It is always a good idea for the judge to read your heads before coming into court or before the hearing. Very important. The judge will listen to you, and I say, be as eloquent as you can in the circumstances. I'm not saying abandon your eloquent style. Never do that. That's who you are. That's the way you present argument as a good lawyer. But the argument will be about addressing queries around your material points in your heads of argument. That's what happens in a virtual hearing. The judge read your heads. The judge will tell you, I've read your heads. I merely need you to deal with the following points. And then deal with those points. The judge will guide you and let you know if you should continue to argue. The judge might indicate that you don't need to present any further, and you can sit down. Now let's look at what the judge is doing. Firstly, the judge will confirm after evidence is complete exactly what the issue is. Now remember, at opening statement, the judge will want to hear from you as to what the tribal issue or issues are. During the course of the hearing, one of those issues might fall away, and you'll be left with a single issue. The judge will confirm exactly what that issue is and will confine you to hearing arguments only on that issue. The judge will expect you to be short. The judge will read your heads before coming into court or coming onto the platform. Once the judge has read the heads, expect the judge to ask you a few probing questions, and it'll be as short as that. When a judge asks questions, be very attentive, because those questions are a clear indication of the judge's prima facie view. If that prima facie view appears to be against you, you will have to work a lot harder to persuade the judge, because now you're going to turn the judge around to come around to your point of view. But if the prima facie view shows that the judge is with you, then there's no need to keep the judge much longer than is necessary. If the judge asks you a query or a question, answer it, short answer, indicate to the judge if there's nothing else, is there anything else that the judge will require? If you prepared excellent heads, you would have anticipated the questions that might come from the judge, and you will be ready to respond. Occasionally as lawyers, and trust me, this happens, especially in the SCA or the Constitutional Court, a question will come that you never anticipated. It's what we lawyers call the curveball. It's the curveball or the googly that comes, and you are not ready for it. You'll have to do the best you can. The judge will not allow you to bombard the judge with authorities. Now, again, please keep it short. What you want in your heads, in your argument, is to tell the judge the latest relevant judgment of the highest court. That's it, no more. Those of you who are familiar with the SCA rules and the Constitutional Court, they tell you that if you make reference to more than one case, you must motivate why you referred to more than one case. In other words, they want you to do this. Cite only the most recent decision of the highest court on the point. That's it. There may be 20 other cases. Don't bother. It's not relevant anymore. You can, my view is that you can deliver persuasive argument on your seat in front of a camera. It gets even easier to present persuasive argument if you wrote excellent heads of argument. You have to be organized. Have all your papers close at hand and flagged for easy identification. Now, that's the old-fashioned way. Very soon, you will not have a bundle that is flagged. You will have electronic bundles, and you will see in a moment how referencing it can be made very easy with the right software in court. Currently in Gauteng, you refer to electronic documents, except that now and again you'll get a judge who doesn't really understand how this works and will tell the parties, okay, he's got case lines and everything, but can you please have a hard copy of the papers? And then we just ignore the case lines after that. One of your heads must be in front of you. Your heads of argument must be at eye level, preferably on a separate monitor or a second screen. It's very difficult to do that in court. You don't have the luxury of multiple monitors, but if you're doing it virtually from your office, then you can have that luxury. It's the same with documentation, discovered documents. Case law can be placed on your second screen, and you can reference it very easily without having to navigate through shared screens. One of the things you never do is read from your heads. Because once you start reading from your heads, you are no longer looking at the camera. What the judge will be seeing while you read your heads of argument is the top of your head. And that's not persuasive, okay? Only use your heads for referencing. Your preparation must be good. You must have absolute command of the main points. Now remember, you drafted these heads. You drafted them very well. It will not be a problem for you to remember the points and to be able to master them while addressing the judge. That is how you present forceful argument. Reading to a judge serves no purpose. The judge can do that himself. Use your advocacy skills. None of this boring monotone stuff, okay? Use your voice. Use the cadence. Use your voice to emphasize a point, okay? You must sound interesting. Now, more than ever, you need to sound interesting because the judge is listening and is listening over a device. You need to come across well. You know, I tell lawyers, if you want to practice in court, if you want to be a trial lawyer, and there are problems with your voice, don't despair. You can have it fixed, okay? You can fix it. You can go to a voice expert. It'll take them 1 week, and they'll sort out your voice. You will project better. You will sound better. They'll even assist you with a difficult accent if you have one. It's an excellent investment. You know, if you grew up in the Boerland, in the Cape, you will definitely need assistance. Or if you're from Durban. It is highly effective to use visual aids. In a trial, you are very likely to have used visual aids, like exhibits, videos, and so on. It is so much easier when you're using electronic devices, either in court, in person, or on a virtual platform. Imagine now, let's say you played a video in court. Well, it's on the system. It's so easy. You can actually play it during argument if you need, if it's necessary. You can call up a picture of the exhibits. So much easier to do. It works so well in virtual hearings. And then I come to something I've repeated here. Never be too long. By now, fatigue would have set in. A judge will not appreciate lengthy argument. Always finish with a strong point. Do not finish with a judge hinting that you should stop. Okay? Don't be in a situation where a judge has to remind you, Mr. Jones, do you think you'll be finished by 11 o'clock? Now, you've lost the judge when that happens. By the way, one of the biggest problems with virtual hearings is screen fatigue. That is why we don't have webinars that run for more than 3 hours, 3 hours maximum. That's because people who attend these webinars can't actually concentrate for all that time. You can't have a webinar for 6 hours. The people can't stay on the screen for that long and concentrate. Finally, I want to deal with the opposed motions. This is perfectly suited for virtual hearings. All of the techniques I explained will apply, but just remember, the judges will rely heavily on the papers. They'll rely on the 3 sets of affidavits. The affidavits must be short, clear out all useless, unnecessary annexures. The secret is to draft excellent papers, including heads of argument. What also works brilliantly, where the facts dictate it, is to use chronology documents. In this court in Johannesburg, for opposed motions, we expect you to file a chronology document where it is necessary, because it helps the judge and it helps you with your argument. I'm going to now stop and hand over to Advocate Goodenough. And then we'll wrap up. I'll take questions from you. If you have questions already, please send them through to Betty. You can already email Betty the questions, and I'll receive them and deal with them later. Okay, Doris, over to you.
Thank you very much, Ishmael. Hello, everyone. My name is Doris Goodenough. I'm an advocate, a member of the Johannesburg Bar, and I have been practicing for more than 30 years in civil litigation. And that includes 30 years of carrying heavy lever arch files, marking them with different colored sticky labels, and standing on my feet in court, shuffling through a file of heavily sticky labeled pages while the judge is wrapping his fingers on the bench, waiting for me to find the document that I want to refer him to. Chapter 26 of Ishmael's book, called Trial Advocacy, The Art of Persuasion, deals with using technology to prepare and present a court case. It explains how Cognotes help solve the problems of handling paper, especially large volumes of paper, and assists you to analyze the facts and easily access and structure the documentary information in your case, beginning the moment the case lands on your desk, and from there onwards through preparation, pleadings, discovery, presentation in court, and to final argument. Using Cognotes, you can dispense entirely with paper, and you can list all the documents and see any of them from anywhere using only your smartphone, tablet, or laptop. You can search the case documents and quickly pinpoint the exact document you are looking for and the exact line on the page you need, no matter how many documents there are in your case. You can research the facts of the case based on the content of those documents and make useful notes that are never lost. You can see all your case notes from anywhere using simply your smartphone, tablet, or laptop. You can show your notes and documents on screen during a web video conference. You can easily create trial bundles, discovery schedules, heads of argument, and more. And you can easily share documents properly marked and paginated. So this is a very different way of litigating to what us older people are used to, and it works extremely well. The case that Ishmael referred to briefly of Daniels is actually using the Cognote system, and it is working very well. That case is a trial that is being conducted by video conferencing. Witnesses are being led, witnesses are being cross-examined. There are 95,000 pages in that case, and they are dealt with in a very, very efficient and effective manner during the trial, and the judge, the witnesses, one's opponent, and oneself can see whatever document counsel wants the judge and everyone else to look at. So Cognote is tried and tested in the real world, and it really works well. The litigant is extremely happy with the service. I'm going to share my screen now and show you Cognotes. Ishmael, can you just give me a heads up to say that you can see my screen that says Cognotes?
Yeah, I can.
Thank you, Ishmael. So this is Cognotes. When you use Cognotes, you will first of all upload all your documents in your case to Cognotes. If your case is already on CaseLines, it is a very simple matter to upload your CaseLines documents complete with index directly into Cognotes. And you will see over here that the stamp, the CaseLine stamp, remains here when the documents are in Cognotes, And the benefit of that is that the judge can trust that whatever you are sharing on the screen with the judge is exactly what it says in case lines, and the judge can make a note as to what documents he wants to refer to on case lines. Just close that window. Oh, I'm sorry. Sorry about that, I pressed the wrong button. Okay, so I'd like to first show you what you can achieve once you have digested and prepared your case using Cognotes. The first thing I'm showing you is an index that I have created in regard to this case. It's a slip and fall case where the plaintiff was injured when a scaffolding of a ceiling fell on top of her head. So the first thing I did is I created issues or topics. So every element of proof in the case was given its own heading. And if I want to look at what notes I have made, for example, regarding the injuries, you will see there the main factual finding that I want the judge to make. The plaintiff sustained a blow to the head and blows to her limbs. And here are the hot linked notes regarding what the sequelae are and what her problems are. So here is the factual statement. And if I want to see the source document, I click on there and I see here a slide. And ballooned out here are the very words from the source document that I want the judge to look at. If the judge says, well, show me the actual source document, I click on there and the judge is taken immediately to the very page on which all the plaintiff's problems and sequelae are listed. This is very helpful when you are presenting your case, for example, as Ishmael mentioned. You know, you can get on your feet to start arguing and you want to start at the beginning and the judge says, no, I've read your heads of argument. Tell me about future loss of income. Now you are sharing your screen with a judge and you'll say, okay, judge, I'm going to now talk to you about quantum of future loss of income. Here, right in front of me and in front of the judge are the evidential aspects which I'm relying on, plus also my submission about that fact. If the judge says, well, where in the trial bundle do I find that fact that her sister has a grade 7? I say, judge, it's in the industrial psychologist report, and there the words are ballooned out, and the actual facts from that document are visible here on this page. So this is what we are aiming at when we are using Cognotes to deal with a case. Once you have got all your documents uploaded onto Cognotes, there are a number of features that will help you to navigate your way easily through the case. In this case, you will see that there are 1,596 pages in 83 documents. I'll now give you an example of how easy it is to find a particular document simply by knowing one of the words in the name of that document. So I want a document whose name includes the word particulars. There I see there are 4 documents whose name includes the word particulars. If I want to narrow it, and I can say, well, I want to see the documents whose name contains particulars and return, I click on there, I see the exact document that I was looking for, and I click and I immediately see the document. The judge can see it, my opponent can see it, and if necessary, the witness can see it too if I want to cross-examine him about that particular page. This saves a lot of stress for counsel, for the attorney, and for the judge, because he doesn't have to be irritated while you're shuffling through your lever arch file looking for documents. In addition to being able to find a document by name, you can also search the contents of all your documents on Cognotes. The reason for this is that once you have uploaded your documents to Cognotes, the Cognotes system will convert them into readable, searchable text, OCR. That means that Cognotes can read everything that's in your documents and search for them and produce them to you within seconds. There are several layers of searches in the filters, which makes your search very easily refinable so that you don't get bombed with too many pages and too many hits. So let us say I want to find a case, I want to find a page or all the pages in my 1,500 pages that contain these three words, plaintiff, injuries, and damages. I write in those three, and so I'm now doing a proximity search, everything on one page. There I find there are 8 hits where those three words occur on the same page. I could narrow that search further by saying, only show me those three words on a page where they appear in the pleadings. And there I see that is now only 3 hits. I could then further narrow the search and say, only show me the documents where those 3 words appear on a page in documents that were created within that date range. And there I will find the one single document that contains all the 3 words that I want on that page and that complies with the search criteria. So within a minute, I have found the exact page out of those 1,500 pages that I was looking for. This kind of thing happens in court. Let's say your witness is being cross-examined and your opponent says, oh, but you said this in that document, or that document says this. And then while everyone's shuffling through their lever arch files, the judge is hearing, oh, goodness, this witness said something else. But here you can instantly find the document that will refute what your opponent is saying, and you can make a note of it and raise it in re-examination. Sometimes during argument, the judge would ask you something and say, well, where in the papers does the following appear? Or is there anything in the papers that talks about this? And you can answer that judge and find your document within seconds. And that helps to maintain the flow of your case, helps you to stay in charge of what's happening. Another kind of search that you can do is a date search. When you upload your documents to Cognotes, Cognotes scans and scavenges through every single word in all documents to look for anything that looks like it could be a date. That could be a date written as 1 April 2019 or 010419. Anything that looks like a date, it will gather up and it will collect them and allocate them to dates and years. So if I know that there was a reference to something that happened in April 2019, I click on there, I fetch the dates, and Cognotes then gives me the context around all the places where a date within that month and year appears. So I can look down here. Here I see, oh yes, this is the one that I want. And I can see there's the reference to 5 April 2019. He was talking about the occupational therapist. That is a very, very quick way of finding exactly what you want with no fuss and no hassle. I'd now like to show you how easy it is to make a note. And a note is the building block of that page I showed you earlier, which had all the notes beautifully allocated under their relevant issues. I'll now show you how to make a note. So when I, as an advocate, or you as an attorney, are looking at your file and you want to find out what the evidence is, the relevant evidence, you would usually go and look here in your discovery documents. And here let's say I want to read this report of the industrial psychologist John Wayne. So I start reading the report, and the beauty of this is this can be the very first time that you're looking at this report. And so as you're looking at it, you see something, oh yes, that's important. There and then I click here on Note, and instantly I see that Cognotes has given me in copy-pastable format the text that I want to highlight and comment on. So I highlight it, and here in this little text box, it says, it gives the information that I want. So now I'm going to make a note of what the factual evidence is. The first thing I want to make a note of is who says this, who's the witness who says that. So it's the plaintiff, and I'll say plaintiff was injured in an accident. In other words, just a thumbnail of what the fact is that you want to rely on. I can then include this fact in a chronology. And Ishmael was talking about the importance of chronologies. I'm going to show you a hot linked chronology that you will be automatically generating simply by going through your documents and saving items for a chronology. So the date for the chronology here would be the date of the accident. There it is. In addition, I can now ask myself, this fact, to which issue in the case is it relevant? To which of the facta probanda is this fact or piece of evidence relevant? And I say it's relevant to the incident. So I save it there under the incident. And I save it. Okay, now I'll show you in my notes that this note that I've just made has been saved. There, it says plaintiff was injured in an accident. Where do I find it? There it gives me the source of that fact, and one can look at the source document and you can see it instantly over there. In making that note, I've also simultaneously created an entry for my chronology. So here you can see there's my note, 20 October 2016, the plaintiff was injured in an accident. And if I give my chronology to the judge or my opponent like this, they can easily verify that the information is what I say it is because I'm referring to the actual document and so that can be tested. So the significant thing to remember here is that everything that you're seeing here can be shared with a judge, either in court or it can be sent to the judge by way of inviting the judge to join Cognotes. Now I would like to show you, wait, hold on a sec. I just want to get out of this one. Stop sharing. Now I'm going to share with you the heads of argument. Those notes that I showed you at the beginning, with a click of a button, are converted by Cognotes into a hot linked PDF, which you can really use as your heads, or you can tinker with them and modify them. But every heading, there's a heading for every issue in the case. There's your proposition, whether it's a matter of fact or law. So let's say you've emailed the judge your PDF heads. The judge doesn't even need to be on Cognotes in order to use this. As long as the judge has got access to the internet, you can email this to the judge who will open it on his or her computer. And there you see, I've referred in these heads to a statement of law. Click on that link, and there you can see that there's ballooned out the words that I was relying on for my statement of law. And here on the left is the exact page from the judgment on which I rely. The judge can scroll through here. He can read the whole judgment if he wants to, and verify that I was actually telling the truth when I said that that is what that case says. So that hot-linked PDF is a very valuable document to use in court, and it means that you don't have to keep on doing the same thing. You don't have to keep on and on making notes and ordering the sequence of information. That very first note that you made the very first time that you read the case or read those reports, there your notes are. So when you are preparing your heads of argument, you don't have to go and put in footnotes and things like that. There's a hot link, and it is extremely useful for the judge, and also obviously during the presentation of your case. I'd like to now show you again in Cognotes another way of presenting your case. Sorry about this. When you have made your notes and you want to present them, you can also present your closing argument as a slideshow. So here are the slides. Here is a slide of the list of statements that are made in support of your main proposition that the second defendant was negligent. You can then click on there and you can share your slides with the judge, and this can be your method of presenting your case. So I'd like to summarize now what I've just said by means of a very, very short slideshow. Can you see my screen?
Yeah.
Thank you. Okay, so to summarize, Cognotes helps you and enables you to deal with your case from the beginning of preparation right through until presentation. Presenting with Cognotes makes it easy for the judge to follow what you are saying and enables you to quickly find the exact page. In summary, what Cognotes can do for you is search. Sophisticated search features, multiple layers of search filters, making notes. Your notes are a thinking tool that you use from the beginning, and they are the starting point for heads. And most important, they are never lost. They're always exactly where you need them and where you'll be looking for them with a click of a button. The end result of making your notes is a well-organized list of notes per issue with a factual summary, a hot link, and your submission. How do you present your case in court? You share your Cognote screen with the judge and your opponent. You can also email your hot-linked PDF heads to the judge and to your opponent. Privacy. You have got two-factor authentication with Cognotes. So it is an extremely reliable way of protecting your notes and all private comments and thoughts that you've put down. Nobody can see what you've written in Cognotes unless you want them to. When you use Cognotes, even if your opponent is not using Cognotes, you can invite your opponent to have their own team. You can also invite the judge to be another team, and none of these people can see each other's notes or your notes. So they can use Cognotes courtesy of you who's invited them to become a team. And this is really something which is considerate towards the judge, because you know, the judge, yes, the judge has got case lines, but Cognotes gives the judge so much more. Cognotes enables the judge after the hearing, or even before the hearing, if it's in regard, you know, in an appropriate case, to look at the papers and do searches and prepare himself or herself for the case. So, and it's not difficult. It's not difficult for a judge or even a technophobic person, as some of us older lawyers are, to use Cognotes. How do you access Cognotes? The easiest way, if you are not very techno savvy, is that you can email me your PDF bundles. I'll upload your PDFs to Cognotes and create a hot linked index, or I can train you or your secretary to upload and index your PDFs. There is a free service which will be available within the next month or so, where you can upload from case lines up to 500 pages per case for free onto Cognotes, and you will have the index, the same case lines index will be available to you to click on and open the documents mentioned in the index. That will be for free. There's also another service where, as a once-off, you can upload 1,500 pages in any case to Cognotes and use that as a trial experience. The services that I offer are training, or I can do everything for you, or I could be your IT tech person in court. My service is called Goody Notes. There is the website, and you can visit that, and you can see some short, medium, and long videos where I demonstrate how Cognotes works. You will also see that there is a way where you can just try out Cognotes on my website for free. And I'm going to post now in the chat, I'm going to post my contact details. And if you want to find out about Cognotes and how to sign up for it, there's Cognotes. And if you want support or to any technical questions to be asked or answered, you can email support@cognotes.co.za. And here is my phone number. Please feel free to phone me and ask me more about Cognotes. Thank you very much.
Okay, Betty, it's time for questions. But what I want to say, Ed, is this. The technology around managing your documentation, including pleadings and affidavits, your heads of argument in court, that technology is developing constantly, and it's being improved all the time. This what you saw is an example of a good system that can be effective in a big budget case. What's important to lawyers is to have available an effective search mechanism. Now, most of you will be familiar with electronic law reports like JUTA or LexisNexis. One of the things that frustrates lawyers about them is their search engine, because they use search engines that rely on word recognition rather than use algorithms. The trouble with good search engines which use algorithms is that they're very expensive. But the systems that are becoming available, which, and this is the important bit, you can use it with case lines, which is going to be rolled out to our courts, and that's going to happen as soon as they can deal with all the corruption, the better. It's caused us a setback, but we will get there. The point I want to make is that as practitioners, you should be ready to adapt and use the technology. It makes you more efficient and it makes you more effective in a courtroom, whether it's virtual or in person, it's just as effective. Betty, are there any questions?
None, sir.
Okay. So I'm going to conclude this session. This will be the last in the series of short webinars that we had. I hope you found them useful. I know that many of you attended all of them. I would seriously recommend that you get my new book, this one. It's called Trial Advocacy, The Art of Persuasion. It deals with virtual hearings, but it deals with every aspect of a hearing, and it prepares you to be a very good trial lawyer. And it's the first book of its kind in the country, and it's already become extremely popular with the members of the bar. So it's an easy read. Those of you familiar with my writing, I don't write academic style. It's easy to absorb, and it's also quite fun to read. So get that book. It will certainly assist you. It's available online from LexisNexis. Well, Doris, thank you for presenting that program. It must give all the attorneys and advocates listening food for thought. At least it shows them what is possible and what the future looks like. So even if we are going back to court for in-person hearings, much of the process leading up to the trial will be done virtually. You will not have to attend meetings and drive across town and so on. You will handle your witnesses differently. You will consult your clients more efficiently. And you have to be geared up for it and use the technology. It's unusual for somebody of my age to be talking to you like this. I mean, you're supposed to be the tech savvy people. But, you know, I'm very surprised that the younger attorneys are not as tech savvy as I thought they would be. So get up to speed. Thank you for attending. I must apologize. My voice is not as good as it usually is. I'm still trying to recover. And thank you for attending this course. Okay. Betty, is there anything for me to deal with?
No, we're done, sir.
Okay. Okay. Thank you.